Thank you for joining us today for this third installment in our series of podcasts on COVID-19 issues for employers. The focus of our discussion today is on health and welfare plans. By way of background, the term health and welfare plan encompasses many types of plans, from medical, dental, and vision coverage to disability and vacation benefits to tuition assistance and flexible spending accounts. Now that we're all on the same page, my name is Nida Javaid. I'm an Employee Benefits and Executive Compensation Associate with Troutman Sanders in New York, and I'm joined by our two panelists, Rebecca Alperin, Counsel at Pepper Hamilton, and Lisa Shallue, Counsel at Troutman Sanders. Together, they have over 40 years' experience specializing in employee benefits and executive compensation. And for those of you who are not aware, Pepper Hamilton and Troutman Sanders are joining forces July 1st as Troutman Pepper Hamilton Sanders. On today's podcast, we'll be discussing the Families First Coronavirus Response Act, the Coronavirus Aid, Relief, and Economic Security Act, or the CARES Act, and subsequent Department of Labor and IRS guidance in the context of health and welfare plans. We'll identify some of the required and optional changes to be implemented by health and welfare plan sponsors in response to this legislation and guidance. We hope to help employers figure out what needs to be on their growing health and welfare plan to-do list in light of the COVID-19 pandemic. We'll be discussing group health coverage for COVID-19 testing, extended deadlines for COBRA, HIPAA special enrollment and participant claims, permitted changes to cafeteria plans, and student loan repayments. So we're going to start with a question for Lisa. Lisa, we've seen a flurry of legislation and agency guidance over the past 2 months in response to the COVID-19 pandemic. Can you help our audience identify what changes have to be made to health and welfare plans?
Yes, the amount of information that's been published in response to the COVID-19 pandemic has been pretty overwhelming. Surprisingly, however, there are only a few mandates that apply in the health and welfare plan context. All of the rest of the changes are optional, meaning that the legislation and regulators are not forcing employers to adopt these changes, but are instead providing them with flexibility to decide whether or not the changes make sense for their workforce in light of the employer's particular circumstances. And as we'll be discussing, most of these optional changes apply to cafeteria plan flexible spending accounts in order to allow participants more leniency to use or adjust their contributions in response to the unanticipated COVID-19 pandemic. And now many employers are going to want to take advantage of these changes, in which case appropriate steps are going to have to be taken. And Rebecca will be talking about that in a little bit. But in terms of the changes that have to be made or adopted in response to the FFCRA and CARES Act and related guidance, as I said, there's only a couple of mandated changes. And the first is a coverage mandate, which requires group health plans to cover COVID-19 testing without any participant cost sharing. And that is eventually, that coverage mandate will also eventually extend to COVID-19 vaccines that are going to need to be covered without any participant cost sharing. And then the second mandate, second thing that's required by the federal guidance is a required extension of various participant deadlines.
Got it. Lisa, can you elaborate on what employers need to know regarding the first mandatory change to be made to health and welfare plans that you mentioned, coverage of COVID-19 testing?
Yeah, with respect to the mandated COVID-19 testing, there's a couple of things. The coverage cannot be conditioned upon any type of prior authorization or other medical management requirement. So effectively meaning that as long as the participant's attending healthcare provider has determined that the testing is medically appropriate, coverage is going to have to be provided. And this extends not only to the COVID-19 test itself, but also for the associated office visit, whether that be in person, telehealth, emergency, urgent care, as well as any testing-related service that is provided during that visit. Now, there has been a little bit of confusion regarding the period to which the COVID-19 testing mandate applies, and then how that mandate interacts with high-deductible health plans, given the typical rule that before a high-deductible health plan can provide any type of coverage, there's a required minimum annual deductible that has to be satisfied, and if it's not, then an individual who's participating in the high-deductible health plan is not going to be eligible to contribute to a health savings account. So in terms of the period to which this coverage mandate applies, it begins on March 18th, 2020, which is the date that the FFCRA was enacted, and it will extend until the end of the public health emergency that was declared by the Department of Health and Human Services, the HHS. And that public health emergency is currently scheduled to end on July 25th, 2020, unless, of course, DHHS decides to extend it again, which it could do in 90-day intervals. But after the DHHS public emergency ends, self-insured health plans will be free to choose at that point whether or not they want to impose any cost-sharing requirements on participants for COVID-19 testing. And this could be important for self-insured health plans since the cost of this testing would not have been included in the projected cost for 2020, so it would not have been incorporated into premiums. And rather than absorbing all of the cost, employers may want to mitigate those costs by passing a portion along to participants, again, at the end of the mandate period. And then in terms of the interaction between the mandate and high deductible health plans, relief has been provided to allow the required COVID-19 testing to be covered under a high deductible health plan without regard to the otherwise applicable minimum deductible, and that's not going to interfere with a participant's ability to contribute to a health savings account. But in addition to allowing for the high deductible health plan to provide the mandated coverage, additional relief has also been provided so that a high deductible health plan can also cover COVID-19 treatment and any type of telehealth service, regardless of whether or not it's related to COVID-19. All of these coverages can be provided under a high deductible health plan starting January 1, 2020, and without regard to the otherwise applicable deductible and without interfering with the ability to contribute to a health savings account. The one caveat is that the relief for telehealth coverage, that's temporary, so it's going to be ending at the end of the 2021 plan year unless we receive additional relief. Another thing for an employer to keep in mind is that in addition to the federal coverage mandates, there could be state laws that impose additional coverage requirements. However, self-insured group health plans would not be subject to those state laws. And if an employer has a fully insured health plan, the insurance carrier rather than the employer is generally going to be responsible for complying with any type of state coverage mandate. So now that we know what COVID-19 and telehealth services must and may be covered, I just want to take a couple of minutes to talk about the steps that employers are going to need to be taking in order to implement these changes. Generally, insurance providers and third-party administrators are going to be primarily responsible for making sure that the coverage is provided, for example, by updating their systems and making sure proper codes are in place to process claims so that they're covered. But there are some actions for employers. For example, an employer is going to need to determine whether or not any of the voluntary changes I talked about whether or not the employer is going to want to implement them. So, for example, waiving participant cost sharing after the end of the public health emergency, or if an employer sponsors a high deductible health plan, is that plan going to cover telehealth services without imposing the deductible or with making it maybe perhaps a lower deductible? An employer also may want to consider for employees who are not enrolled in its group health plan, if it wants to provide some type of limited COVID-19 coverage, it may decide to do that through a standalone telehealth program or an employee assistance program. But in any event, whatever voluntary changes the employer decides to implement, it's going to need to coordinate with its TPAs and also its stop-loss carrier to make sure that everybody is on the same page. Another thing that employers are going to need to think about is providing an updated summary of benefits of coverage or some type of notice describing the new COVID-19 coverage. Typically, this notice, whenever there's a change to an SBC that occurs mid-year outside of annual enrollment, an updated SBC has to be provided 60 days in advance of the change. But in this case, the coverage requirement went into effect very rapidly, so the Department of Labor has waived that 60-day advance notice requirement. However, that's contingent upon the employer providing a notice as soon as reasonably possible. Also, if an employer is going to be terminating COVID-19 testing coverage at the end of the public health emergency, there is going to be a requirement to provide either an updated SBC or some type of notice 60 days in advance. Plan amendments, employers are going to need to review their plan documents and summary plan descriptions to determine, what changes and amendments need to be made to reflect this new coverage. And then lastly, employers are going to want to be on the lookout for the COVID-19 vaccine. Once the vaccine is added as a recommended preventive service, coverage is going to have to be provided within 15 days. So employers are going to want to make sure that its TPA and or insurance carrier is in a position to start providing that coverage right away.
Lisa, you also mentioned extended participant deadlines as the other mandatory changes to be made to health and welfare plans. So the joint notice published by the DOL and IRS on May 4th extends various deadlines that would otherwise occur from March 1st, 2020, the date that the presidentially declared national emergency related to COVID-19 began, until 60 days after the conclusion of the COVID-19 national emergency, meaning that the plan administrators must, quote-unquote, ignore that time period, referred to as the outbreak period, in computing the deadline for a participant to submit a benefit claim, make a COBRA election, a COBRA premium payment, or a special enrollment election. Can you talk about what this means for employers?
Yeah, well, the purpose of this guidance is to help protect against the loss of health coverage and other important participant rights during the COVID-19 pandemic. So it effectively pauses the clock with respect to these rights, meaning that any deadline affecting a participant's COBRA, HIPAA special enrollment, or ERISA claims rights that would otherwise occur during the outbreak period is going to be pushed out until the end of the presidentially declared national emergency. And I just want to note there that the extended participant deadline requirements are tied, the timing is tied to the presidentially declared national emergency as opposed to the HHS public health emergency that is relevant for the COVID-19 testing we just talked about. But in any event, there are a few things with respect to these participant deadlines that employers are going to need to do. Although generally their third-party administrators are going to be responsible for putting new administrative processes in place to accommodate the extended deadlines, it is ultimately up to the employer to ensure that whatever the TPA is doing is compliant with the joint agency notice. And then secondly, employers are going to be responsible for updating their documents to reflect the extended deadlines, and also thirdly, for communicating with employees about these deadlines. So in terms of the first of these obligations, in order to ensure that a TPA the steps the TPA is taking are compliant with the joint agency notice, employers are obviously going to need to be communicating with their TPAs about what the TPA intends to do. And typically what we're seeing is the TPA is going to come up with a proposed solution, how the TPA intends to address these extended deadlines, and then provide the employer with some type of its proposed solution for the employer to approve. Before an employer signs off on the TPA's standard solution, the employer should review the proposal with legal counsel, as it's often going to be necessary to negotiate a more tailored approach with the TPA for compliance reasons. And then obviously if an employer doesn't hear from its TPA about these extended deadlines, it should reach out and inquire. And another thing to kind of be aware of, as these administrators are making changes to their processes and systems potentially, they're going to be looking most likely to pass some of that cost along to an employer. So employers should expect to see some type of fee from its third-party administrator in connection with these extended participant deadlines. And then with respect to the employee communications, employers are going to need to determine how to communicate these new extended deadlines to employees. There is nothing in the joint agency notice describing the required employee disclosure. And the ERISA deadline that would normally apply when to a material modification of this nature, that deadline isn't going to occur until long after these extended deadlines have expired. So that if an employer were to wait until then to inform an employee about the relief would no longer be available. And this clearly is not consistent with the intent of the guidance. So ultimately, I think employers, where they end up, given the lack of guidance, is there probably is some type of a ERISA fiduciary obligation to inform employees about the relief, and sooner rather than later, since employees may not otherwise be aware of the relief or the steps that they need to take in order to take advantage of it. Now, with that said, while I think most people would agree that some type of employee communication is needed, there are a lot of open questions concerning what exactly that disclosure needs to look like and how it should be made. For example, new hire materials, do they need to be updated to include some type of notice regarding the extended deadlines? Because typically, new hire materials wouldn't include this information. What about former employees? Do they need to be notified? And then also for existing employees, some employers, particularly those with self-insured health plans, are understandably concerned about the additional costs and the exacerbated adverse selection that they could be facing as a result of these extended participant deadlines. For example, if some of these COBRA or special election period would have expired normally in March, and now they're going to have until August or later to enroll in the employer's health plan, this is obviously going to increase the employer's risk exposure with respect to high-cost medical claims and emergencies that could occur during that substantially extended period. So in light of this heightened risk exposure, employers may decide to limit the employee disclosure to whatever is minimally necessary. But given the lack of any specific guidance regarding the required employee communications, it's probably a good idea to consult with legal counsel to determine how, when, and what to disclose to employees. And then with respect to plan amendments, all of the extended deadlines apply to items that have to be included in an ERISA summary plan description. So COBRA, HIPAA special enrollment, and claims procedures. These are all items that must be included in an SPD, and whenever there's a change to a required SPD element, a summary of material modification is needed. So as a result, plan documents are going to need to be updated, and that generally should occur by the end of 2020.
Okay, so Lisa, as employers work on these employee communications, plan amendments, and vendor negotiations to implement these mandated extended participant deadlines, are there any particular challenges or pitfalls that they need to be aware of?
There are actually a number of complexities created by the extended participant deadlines, and that's due to a couple of factors. First, as we said, the guidance was not published until over 2 months after the protections take effect. So meaning that if a participant has previously lost any of these protections during that retroactive period, steps will need to be taken to reinstate that right. And then secondly, the national emergency is still ongoing, so we don't know when these protections are going to end. And that is effectively placing things like COBRA election and payment periods, special enrollment periods, and claims filing deadlines in limbo. And if we look at each of these items, a number of questions immediately come to mind. For example, with COBRA, if an existing COBRA participant fails to timely make a COBRA premium payment, or a potential COBRA beneficiary fails to timely elect COBRA, what should happen to the participant's health coverage? Should it be canceled, subject to retroactive reinstatement, if the participant later does enroll within or pay within the extended time frame, or should the coverage be continued, subject to retroactive cancellation? Typically, a TPA is going to cancel the coverage, subject to reinstatement later if the participant elects or pays. But if the coverage is canceled, what happens to the claims incurred, following the cancellation? Do we just deny them and then reprocess them if the participant later elects or pays for COBRA, or do the claims just get pended until the end of the extended election and payment period? Keeping in mind that the gap between the normal expiration of these deadlines and the extended deadline could be up to 8 or longer months, depending upon how long the national emergency lasts. And this is problematic not only for plan administrative purposes, but also for participants who would now need to come up with 8 or more months of retroactive COBRA premiums. Also, what about the COBRA notices that are provided during this outbreak period? they're going to need to inform participants that the otherwise applicable 60-day election period has been extended to a date that is still not determined. Now, I think that rather than modifying existing COBRA election notices, COBRA administrators are probably going to include some type of cover letter or insert with the standard COBRA election notice. And just wanted to mention, in terms of the COBRA election notices, that the Department of Labor did recently, on May 1st, update model COBRA notices. So that's another thing that employers will want to be looking at in terms of their COBRA election notices, to make sure that this new model language is also included in those notices, along with the information about the extended participant deadlines. Another complication relates to those folks whose COBRA election period expired after March 1, but before the date of the guidance, or if their COBRA cancel was canceled due to non-payment of premium during that time. Typically, former employees who are no longer enrolled in the employer's health plan are not really going to be on the plan's records in terms of participant communications. And so, and there doesn't appear to be any obligation to go back and identify these folks. Nevertheless, if these individuals come forward and request enrollment within the extended time frame, an administrator is going to need to ensure that there are systems in place to accommodate those requests. And then turning to HIPAA special enrollments, similar issues arise with the extended deadlines for special enrollment. Unlike COBRA, most HIPAA special enrollment applies on a prospective basis rather than a retroactive basis, with the exception of the enrollment of a newborn. So what this means is that an employee who experiences a HIPAA special enrollment event, like a loss of other health coverage or marriage, is going to have to be allowed to enroll in the employer's health plan if their special enrollment period, which is normally 30 days from the date of the event, but if it expires anytime between March 1 and 60 days after the end of the national emergency, the plan is going to have to allow that person to enroll. But enrollment is going to be prospective, generally, with the exception of a newly acquired dependent due to birth or adoption. And then lastly, the extended deadlines with how that's affecting ERISA benefit claims. We've had some questions as to whether or not this applies to flexible spending accounts. And the answer is yes for health flexible spending accounts, because they are subject to ERISA, but not for dependent care flexible spending accounts, since they are not ERISA plans. And in terms of the health flexible spending account, if the run-out period in which to submit a health FSA claim that was incurred in 2019, if that run-out period normally would have expired after March 1, it's now going to need to be extended out until 60 days after the end of the national emergency. And that means that any remaining health FSA balances are not going to be forfeited until that time. And then additionally, any claim denial letter for any ERISA benefit, that it's going to need to include the extended period that a participant has to submit an appeal or to request external review. And then also the time that a participant has to actually submit the appeal or to submit a claim is going to need to be told during the outbreak period. But employers, on the other hand, are not given additional time to process these claims and appeals. So the regular ERISA claims timeframes continue to apply to the employer in terms of the time that they will have to process the participant claims.
Thanks, Lisa. Let's switch gears and talk about discretionary changes. Rebecca, now that Lisa's covered the changes that have to be made to health and welfare plans in response to COVID-19, can you talk about some of the optional changes available to these plans? Lisa indicated that many of these changes relate to cafeteria plans, allowing participants more leniency with respect to their flexible spending accounts. What exactly can employers do to help participants who are facing uncertainty with their medical and childcare expenses due to the COVID-19 pandemic, and they need flexibility to make changes?
Well, great question, Nida. Typically, a participant is not able to make mid-year changes to her cafeteria plan elections unless she experiences a permitted change in election event, like a change in marital status, a significant change in the cost of coverage, or a change in the number of dependents. So, in the event a participant faces a period of uncertainty, like what is happening now with the COVID-19 pandemic, her ability to make changes to her cafeteria plan elections would be limited. However, due to the unanticipated changes in a participant's medical and/or child care needs caused by COVID-19, the IRS has released guidance which relaxes these rules and permits prospective mid-year cafeteria plan election changes for the 2020 calendar year only, provided the plans still comply with the non-discrimination rules applicable to cafeteria plans, and also extends grace periods for flexible spending accounts. If adopted by an employer, participants may make prospective changes to their elections without having to experience a permitted change in election event and without having to demonstrate a specific pandemic-related need. I want to reiterate that these are optional changes. An employer can adopt changes to one or more or none of these programs. Let's look at each of these programs. Dependent Care FSAs. The rules governing dependent care FSAs already allow elections to be changed due to changes in child care or child care expenses. For example, if an employee is working from home and no longer using child care, the employee could elect to discontinue contributions to his dependent care FSA. However, under the new guidance, and if permitted by the employer, employees could elect to begin or cease participating in the program without experiencing any change in child care costs. General purpose and limited purpose health FSAs. If permitted, employees could elect to participate, revoke a prior election to participate, or increase or decrease a contribution amount previously elected. For example, an employee's salary has been reduced and she can no longer afford to contribute to her health FSA at the same amount. She could elect to reduce her health FSA election amount or stop contributions entirely. Employers also have the flexibility to limit the parameters in which elections can be made. For an example, an employer could limit changes to increases only or limit changes to participants who have a positive balance in their health FSA account. Finally, let's look at employer-sponsored health coverage. If permitted, the employee could elect to participate or switch his coverage option, including self-only to family coverage. The employee could also revoke his prior election to participate, but he must provide certification of enrollment in other health coverage. The IRS has provided sample certification language for employers to use. For example, an employee who initially declined to elect employer-sponsored health coverage elects to participate after experiencing an unexpected illness requiring ongoing treatment. It's important to note that employers who want to permit health coverage election changes will also need to consult with their group health plan's insurance or stop-loss carrier and third-party administrator, as such changes may not be permitted due to adverse selection or cost concerns. Finally, the IRS notice only applies to coverage elections made on a pre-tax basis through a cafeteria plan. If employees pay for their health coverage on an after-tax basis, they would not be able to make these special mid-year election changes. Instead, employers and/or insurance carriers would determine what restrictions will apply. In any event, the newly permissible changes to participant cafeteria plan elections cannot be made retroactive, and no refunds can be given under a plan for non-use of services. So that if an employee stopped using child care in mid-March due to stay-at-home orders, he cannot request a refund for the months that he paid into his dependent care FSA but did not use child care services.
Rebecca, is there anything employers can do to help employees spend down money accumulated in their 2020 FSA accounts?
Yes, employers can amend their health FSA and/or dependent care FSA to extend the deadline to submit eligible health FSA and dependent care FSA claims. Also, if the plan already includes a grace period, employers can extend the grace period for incurring claims to December 31st, 2020. Non-calendar year plans that started in 2019 can also extend the coverage period to allow participants to incur claims through December 31st, 2020. Before I finish up talking about FSAs, there's also two additional changes worth noting. First, the CARES Act expands the definition of eligible medical expenses for purposes of health FSAs to include all over-the-counter medications without a prescription and menstrual care products. Although the CARES Act expands the definition of medical expenses to include these items, employers are permitted to apply more restrictive health FSA reimbursement rules. For example, some employers may find administration of over-the-counter medications without a prescription to be too administratively burdensome, although we suspect that most employers will want to allow for health FSA reimbursements of these newly permissible expenses. Second, if the employer's health FSA includes a carryover, the maximum carryover amount for 2020 is increased from $500 to $550. Beginning with plan years commencing in 2021, the carryover amount will be indexed to reflect an amount equal to 20% of the maximum permitted health FSA contribution for the plan year. Employers can always choose a carryover amount lower than the maximum. I want to reiterate, because it's important to understand the distinction, that while both of these changes are permanent changes, first to the definition of eligible medical expenses, and second to the maximum amount of carryover, employers can always choose to implement provisions that are more restrictive. To wrap up this question, employers should take the following actions with respect to their FSA plans. First, employers that adopt any of these optional cafeteria plan benefits must amend their cafeteria plans. The amendment deadline is generally December 31st, 2021. However, if an employer wants to apply the expanded health FSA definition of eligible medical expenses to include over-the-counter medications and menstrual care products, any amendment would generally need to be adopted as soon as possible, in any event, by December 31st, 2020. However, an amendment will not be needed if the employer's plan simply references any eligible medical expenses as set forth in Code Section 213(d). If an employer has both a health FSA and an HSA, extending the health FSA grace period will disqualify a health FSA participant from making or receiving tax-qualified contributions to the HSA during the extension period, unless the health FSA is a limited purpose and/or post-deductible health FSA during the grace period. So that's an important point to note. Finally, any plan changes must be communicated to employees.
Thank you, Rebecca. What can you tell us about telemedicine? Is it here to stay?
Well, it's unclear, but it certainly won't be used as widely unless additional legislation is passed expanding its availability. Let me explain. The CARES Act ushered in the temporary expansion of telehealth and remote healthcare services by allowing HSA qualifying high-deductible health plans to provide telehealth or other remote healthcare services for all medical conditions, not just COVID-19, with either no deductible or a reduced deductible without destroying HSA tax advantage contributions. But this relief is temporary through the end of 2021, or in the case of a non-calendar plan year, the date in 2022 when the plan year that began in 2021 ends. After that, the pre-COVID-19 high-deductible health plan rules will apply, which generally require a minimum annual deductible to be satisfied before the high-deductible health plan will cover telehealth services. The exception to this general rule is in the case of telehealth services related to COVID-19, which will continue to be eligible for the IRS relief discussed earlier in this podcast by Lisa. Therefore, while telehealth services have proven their worth during the COVID-19 pandemic, high-deductible health plan participants will be limited in their ability to access telehealth services in 2022 unless additional changes are adopted. In the meantime, employers with high-deductible health plans that would like to offer pre-deductible coverage for telehealth services for the next couple of years should contact their carriers to amend their contracts accordingly.
Rebecca, in addition to the changes you discussed that may be made to cafeteria plans and telehealth programs, are there any other changes that employers might want to consider with respect to their health and welfare plan?
Yes, the CARES Act expands the existing definition of educational assistance expenses that can be provided by employers through a Section 127 education program. This is a temporary expansion that allows employers to provide up to $5,250 per employee in tax-free assistance for student loan repayments in 2020 only. Such payments are excluded from both the employee's income taxes and the employer's payroll taxes. This provision applies to student loan repayments for any qualified education loan. which is defined in Internal Revenue Code Section 221(d) and is very technical. In a nutshell, it includes loans for tuition, fees, and room and board expenses incurred by students who are enrolled at least half-time in a degree program at an accredited post-secondary institution. In addition, loans that refinance a qualified education loan may be treated as qualified education loans. An employer that wishes to provide these pre-tax student loan repayments will need to amend its Educational Assistance Program, or ADOPT program, to include this benefit and notify employees. In addition, there are some open administrative issues that employers will need to address, but additional IRS guidance is required. For example, an employer's responsibility for determining whether a student loan is a qualified education loan is unclear. Specifically, is an employer able to rely upon an employee's self-certification as to the qualified status of the education loan, or is additional documentation required? Additionally, it's unclear if the CARES Act relief applies to pre-employment qualified education loan expenses. Although it appears that Congress did in fact mean to include pre-employment loans, IRS guidance clarifying the scope of the temporary exclusion is still needed, as well as guidance addressing an employer's responsibility when making and reporting payments. The CARES Act also provides relief to individuals with federal student loans by suspending their monthly payments through September 30th, 2020, without any interest accruing. Employers can coordinate the $5,250 employer-provided assistance with the resumption of student loan repayments in September to provide employees with extended relief. Alternatively, the employer-provided benefit could be used to provide assistance for those who have private loans and therefore don't qualify for the automatic suspension.
Thanks, Rebecca. So it seems like every time we start to grasp new legislation or agency guidance, something new is published. With Congress considering a fourth round of COVID-19 legislation aimed at recovery, do you both have any final thoughts as to what employers might expect with respect to health and welfare plans? Lisa, we'll start with you.
Sure. There's a lot of uncertainty regarding additional COVID-19 legislative relief. Although the House did pass the HEROES Act on May 15th, I don't believe there's been any timeline for further negotiations by the Senate or the White House. In the meantime, one of the health and welfare plan items that employers might want to be on the lookout for is perhaps a federal COBRA subsidy, similar to the COBRA subsidy that was provided in response to the 2009 recession, in order to help those who have lost their jobs who have been furloughed. In fact, the HEROES Act did include a 100% subsidy of health plan premiums for terminated and furloughed workers enrolled in COBRA. It is unclear, however, whether the next round of legislation that is ultimately passed will include a COBRA subsidy. For example, there's a lot of debate regarding the appropriate subsidy amount needed to bolster COBRA enrollment because COBRA is considered so unaffordable to many participants, and then also whether a COBRA subsidy is the best use of federal expenditures aimed at recovery. So only time will tell, but I don't know if employers should count on seeing a COBRA subsidy in this legislation. Rebecca, how about you? Any thoughts on what we might expect to see for health and welfare plans in the next round of COVID-19 legislation?
Yeah, we might see further extensions of existing relief. For example, further expansion of permissible pre-deductible, high-deductible health plan coverage without affecting eligibility to contribute to an HSA, such as allowing primary care visits to be covered without any cost sharing until the COVID-19 dilemma has passed. Possibly an extension of the mid-year election changes currently available for the 2020 to 2021 calendar years, or extension of the temporary pre-deductible, high-deductible health plan coverage for all telehealth services, not just those related to COVID-19, and extension of the waiver of out-of-pocket participant costs for COVID-19 testing, and possibly a new waiver of out-of-pocket participant costs for the treatment of COVID-19. Also, cost containment measures like a cap on costs for mandated out-of-network coverage of COVID-19 related services has also been advocated for, and relatedly, so has a ban on surprise medical billing from out-of-network providers. Employers might also see additional agency guidance regarding whether certain items such as medical-grade face masks and hand sanitizer constitute qualified medical care expenses, and whether certain types of recent health plan changes would constitute a significant improvement in benefits under the cafeteria plan rules, such that an employer whose cafeteria plan allows for election changes under this circumstance could choose to allow a new election opportunity for employees to enroll without amending the plan as permitted under the guidance discussed earlier in the podcast.
Thank you very much, Lisa and Rebecca, for sharing your collective wisdom with our listeners. And thank you to our listeners. We've covered a lot of material, and as previously mentioned, new guidance is constantly being released. If you have any questions about what you heard today, please do not hesitate to contact us. You can also visit the Pepper Hamilton Troutman Sanders COVID-19 Resource Center, available online, where we have even more resources about the Families First Coronavirus Response Act, the CARES Act, and COVID-19, including a series dedicated for human resources professionals, which provide user-friendly roadmaps for HR professionals to navigate COVID-19 regulations. You can subscribe and listen to other Troutman Sanders and Pepper Hamilton podcasts wherever you regularly listen to podcasts, including on Apple, Google, and Spotify. Thank you again for listening, and stay safe.
These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Sanders does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal and other non-commercial educational purposes. No other use, including without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Sanders.